Should ignore. Maybe others, yeah. You're not seeing others. Then yet. Great. Good. My name is Phil Weiser, and I am Colorado's Attorney General. I am here today because we just had an argument before the United States Supreme Court in the case 303 Creative versus Elenis. The case deals with Colorado's anti-discrimination law and a particular provision known as a public accommodations requirement. The basic idea is if you open your doors to the public, you have to accommodate all comers. You can't deny someone access to a product or service based on who they are. We have in Colorado a number of protected classifications, including race, gender identity, sexual orientation, and religion. In this case, someone would be denied access, in this case, gays or lesbians, to a wedding website because they are a same-sex couple. As this case made clear, if you have a categorical exemption and you say the same exact wedding website will be sold for an opposite sex couple, but then it won't be sold for a same-sex couple, what you've done is deprive someone, based on who they are, access to the marketplace. The deprivation of this would come in the form of an exemption that would be created because of a so-called expressive interest. This expressive interest would not be limited based on religion. It would be anyone's moral objection. In our argument, we made clear that a case involving law schools, known as Fair versus Rumsfeld, there is a requirement that law schools had to open up their doors and allow the military to recruit, just like any other employer could be going on campus. The selective exclusion of the military, even though there was an expressiveness behind it, was said to be problematic and was not justified on the expressive interest. We've asked for that principle to apply here. The United States joined us as an amicus. The argument lasted almost 2.5 hours, was wide-ranging. In the argument, it was clear that the justices understood the gravity of this case, both the importance of protecting the principle that we're advocating for, a principle that has roots in the 1860s in Colorado, where we first adopted a public accommodations requirement. And also, the court was reluctant to find an easy exemption because there was a lot of concerns mentioned by a number of justices about situations that if you had this exemption, it could easily spread to cover a range of other scenarios. We won't expect a decision probably until June, and until then, we will be awaiting the final judgment. I am happy to have people raise their hands to be called on, and then I can call on them. All right, Megan, Max could admit you to the main room so you can ask your question. Go ahead, Megan. And if someone wants to put the question in the Q&A, I can pick it up there as well. Megan, I'm not hearing you. If you can't speak, maybe you can put your question in the Q&A. For some reason, you're muted. Megan, you might try unmuting yourself one more time and see if that works. Okay, Megan, I'm still not hearing you. So if you put yours in the chat, I'll be happy to answer your question. Happy to have others either put their questions in the chat or raise their hands.
Hey there, can you?
Oh, Megan, I can hear you now.
So sorry. So yeah, I was just wondering how you felt that oral arguments went today, and if there's anything was there anything you weren't expecting when it came to some of the arguments that were presented and the kind of hypotheticals that were presented, or anything that you might have done a little bit differently in hindsight?
So Eric Olson, our Solicitor General, argued this case in, I thought, tremendous fashion, making our points clearly and succinctly. It is not easy to do that as the court is having you juggle matters in real time. I would say what was a pleasant surprise was how quickly Justice Kagan cut to the chase. It was really probably minutes into the argument when Justice Elena Kagan asked the question, if a website was already created for one person and someone else wanted the exact same website, but they were a same-sex couple, would you refuse it? And what basis could you come up for that? And what that revealed was what was really being asked is a categorical exemption that all same-sex couples can't be given a website, even if what was being given you might view as highly functional. And that was something she made clear in her hypothetical. What if all there were just the facts? And that's important here. And Matt, your question now nicely segues from Megan's question, because that underscored a point that we were making. This business, 303 Creative, has yet to refuse any couples, has yet to make any websites. So that complicates matters, because if the court were to rule in their favor, it's not as if we have a clear set of facts that the court is ruling based on. The court is having to rule, if you will, on the face of this for all sets of facts, which to our mind raises a concern, and Elliot, your question comes right on the heels of this, of an overbroad exemption. The implications of a win for our side is we are able to continue to enforce a public accommodations requirement that, as I mentioned, have roots for hundreds of years. Colorado's had one since the 1860s. We believe this principle, you open up your doors to the public, you serve all comers, is an important one. It protects access to the marketplace and prevents people from the indignity of being told, we don't serve Jews here, we don't serve women here, what have you. Now, if they try to open up this exemption without any facts to, in effect, tether the exemption to specific type of speech, all that has to happen is a broad statement, I don't believe in serving gays and lesbians for my wedding website company. That means I've got a book company and I sell Jewish books. I don't believe in serving Muslims in my store. That means I make cookies and they're, a cross cookie. I'm not going to sell to non-Christians, et cetera, et cetera. That's a pretty far-reaching implication that undermines a core civil rights commitment. We've not seen this in American law before. It is a real risk to see it in this case, and that's why we're fighting so hard to defend Colorado civil rights law. All right, so I think that covers Matt's question and Elliot's question. Happy to have any follow-ups if you have them. Megan's question is good follow-up. How far-reaching could a decision, a case like be? The Supreme Court is going to have to decide this. Is there a way to narrow the decision, or is the decision going to be more far-reaching? We have offered, I think, a principled decision, which is don't allow someone to get this categorical exemption. We stated that there could be situations where there is a compelling basis where someone's own view would justify some type of exemption on specific facts, but those facts aren't before the court. The risk, if you rule for the other side, is you could create a very broad exemption that could do a lot of damage. We urge the court not to do that. Alexis, I think Max can bring you up to ask a question now.
Hi, can you hear me?
I sure can.
Okay, so I was wondering if you could describe how, refusing to make a website for a same-sex couple is different from what the argument is of refusing to make a website for someone who is racist and wants to put a racist website up there.
This was an important point, Alexis, that came up in the argument. And I believe the thrust of the discussion, the argument makes very plain, there is no difference. If one tries to create an exemption somehow and say, my religion doesn't allow me to do something, that doesn't even offer that much of a limiting principle. I should underscore, this case is not a religious case. It is not about religious-based concerns or an exemption based on religion. It's a broad free speech claim, which means anyone's moral objections would be relevant. Even if this was religion, and this came up in a colloquy with Justice Jackson, there were religious-based objections to interracial marriage that were advanced. And one could easily imagine, based on a ruling in this case against the state of Colorado, that someone would say, my religious views or my moral views say I can't serve interracial couples. We don't believe there's a clear line between same-sex marriages or interracial marriages or denying access to a product or service based on sexual orientation, based on religion. And of course, Justice Sotomayor noted people with disabilities also could have products or services denied. This is indeed the material risk that we raised, and we believe this is a reason the court should be very careful in ruling against us and undermining Colorado civil rights law. Question that Megan says, how is this case similar or different to the Masterpiece Cake Shop case? Two major differences, and they are related. First, this case is what you might call a facial challenge on the face of the law or a pre-enforcement challenge. That means there are no relevant facts here. There were no websites ever made. No one was ever turned away. In Masterpiece Cake Shop, there was an actual marketplace transaction that generated the case. That case was decided on a pretty narrow ground about what was judged to be some animus based on religion. In this case, there's no evidence or concerns that have been raised based on any type of animus or other prejudice. This is a case without any facts at all, and that makes it quite different. The other thing is, in that case, there were a bit of discussion about religion. This case is not a religion case. The issue is solely free speech, which means any rule of law adopted in this case would apply to anyone's moral or other expressive views, not merely one's grounded in religion. Megan asks, how much weight will the court put on custom-made websites versus plug-and-play websites? And what I think the argument underscored is that may be more of a spectrum than an on or off switch, which is to say a pure plug-and-play website where people enter information in and there is no association at all with the host entity might be, in effect, not judge speech. That was an idea that I believe Justice Gorsuch may have mentioned. But here's the problem, as Justice Kagan noted. You could have a standard website based on previously created websites where someone says, I want that exact same website and it's pretty functional, just put my name into it. That is, let's call it an inch different from a plug and play website. Not to afford access to that website means you're really allowing someone to get a exemption, because someone could say, I don't offer any plug and play websites. I have to put in everyone's name manually. And that could create, in effect, less access to goods or services in the marketplace, not to mention the dignitary interest or the indignity of being told, I won't serve you based on who you are. Matt says, it's not a case about religion, but she says it's about religious beliefs. Matt, I want to be very clear. When I say it's not about religion, I mean it's not about freedom of religion as protected by the Constitution, because a religious liberty claim is not before the court. All that is before the court is a free speech claim, which can include one's speech based on religion, but it's not limited to religion. The court is not able to, in this case, make a decision that based on one's firmly held religious beliefs, then the following would be the principle, because there is no religious-based liberty claim left in this case. This case is only a broad free speech claim. That means whatever decision the court makes in favor of 303 Creative would be a decision in face of anyone's free speech interests, no matter how odious those views are. This case cannot, because of the nature of the legal claim, be decided based on the theory that Ms. Smith has a firmly held religious view, because this case is not invoking the religious clauses of the First Amendment. This is a broad free speech clause, which means anyone's moral views, however odious they are, would get protected under the free speech clause with a ruling against the state of Colorado. Alexis, in light of the recent Club Q shooting, how do you think the Supreme Court ruling could affect the lives and safety of the LGBT community in Colorado? This case is about whether or not our laws send the message and enforce the principle that everyone needs to have access to the marketplace and be treated equally. Once we in Colorado and we in the United States depart from that principle, we start allowing under our laws this discrimination that we know has happened in our history. We're taking a step backwards. The principle that we are fighting for is that if you're a public business, you have to serve everybody, and you can't engage in the practice that we've seen in our history. No Jews allowed, no Blacks allowed, etc. If we start excluding people based on who they are, we are sending a message. We are forcing people to suffer an indignity that goes against a commitment that our nation had at our founding. E pluribus unum. From many, we are one. Elliot, what are your thoughts or concerns a ruling against the plaintiff could force a situation put forth by the Jewish Coalition for Religious Liberty? A Jewish baker could fill the crest of the neo-Nazi. Happy November 9th, a reference to Kristallnacht. The critical point that we made, any baker gets to design their products. What they can't do once they've designed their product is say, I'm not going to sell it to you based on who you are. As Justice Kagan's question noted, you can have a situation where someone has already designed the product. It can say in the product, we celebrate marriage as envisioned by the Bible. But once you've designed that product, the website that you created with whatever typeface and graphics you want, you can't limit who buys it based on who they are. Final call for questions, either want to ask them or put them in the chat. Well, I appreciate all of you joining us today. This is a very important case defending a critical principle to Colorado and our nation. Again, we expect a decision in June. We will, again, make ourselves available when you have questions. Lawrence Pacheco, our communications director, and someone who I believe all of you know. Please be in touch. And for those I don't see before the holidays, happy holidays.